Hi. Welcome to the second episode of our talks about distribution agreements worldwide, dedicated to Mexico. Our speaker today is Joaquin Rodriguez, our expert based in Mexico City, interviewed by Roberto Luzi Crivellini. In this episode, they'll discuss how distribution agreements are regulated in Mexico. What are the important clauses in these agreements? What are the main issues in distribution agreements and how to prevent or manage conflicts? Make sure you follow Legalmondo on LinkedIn and YouTube to stay updated on the next episodes.
Hi, Joaquin. Welcome to this third episode of our distribution talks. We discuss about Mexico today, and so thanks for joining. And would you like to tell us how are distribution agreements regulated in Mexico?
Sure. Well, first of all, thank you very much, Roberto, and for taking this opportunity to address some essential feedback from a Mexican law perspective. So let me start by saying that there's, as many other countries, as far as I have seen in Mexico, does not have a law regulating distribution agreements. So in that sense, we essentially are governed by the general rules of contracts, and about its nature, we have a commercial code which essentially governs the purchase and sales of products from a commercial point of view. So that would be a kind of our counterpart legislation for purposes of addressing distribution agreements.
Okay, thank you. And so, if you had to, let's say, address the main points that you advise should be covered in a distribution agreements, what would those clauses be?
Yeah, well, that's a good question because essentially, I mean, since there's no formality for the creation of this agreement, what happens in practice is that this contractual relationship sometimes exists just by the existence of purchase orders, or eventually not even that, just exchange of emails. Because while being no formality, I mean, those contracts can exist with verbal commitment by the parties. So to that end, I would say that some of the essential issues to consider for your clauses in this type of agreements are, of course, the products that you intend to introduce to a specific market. To that end, you may want to agree, of course, in your price conditions, not only for the acquisition of the products. And as I mentioned shortly before, in the distribution, part of the essence to have that nature in Mexico is that the distributor must resell the products. So it acquires them and then it resells. And to that end, and they're taking care of some antitrust law, which would not be part of this conversation, but then you can elect to appoint some suggested resale price, which is another, let's say, essential condition for a purchase and sale of these products. In addition to that, there are some cases where it makes sense to establish some exclusivity, again, taking care of some don't trespass in some limitation from an antitrust perspective. Other thing that it's relevant, which may sound obvious, but sometimes it is not, is the term of the agreement. We have seen in plenty of times that, I mean, these relationships start with no further term, and eventually you end up with a relationship for 20, 30, or even more years, and without any additional regulations, may represent a conflict by the time that one of the parties may want to exit that contract. So the term, although it may be also for an undetermined period of time, but to that end, an early termination clause is advisable. And besides that, another obligation, which may not be minor, as in many other countries, there are matters of public policy. And with this, I mean, those products normally at the end are delivered to the local market. And in that sense, there are issues concerning, let's say, warranty policies or labeling of the products, which in the case of Mexico, in most of the time must be in Spanish. So, I mean, those compliance obligations that do exist because of big public policy, it results advisable that either the provider and the distributor agree on who will be the party responsible for undertaking those specific responsibilities in order not to have a surprise along the road.
Excellent point. Thank you, and well noted. How about, based on your experience, disputes and conflicts between producer, foreign manufacturer, and local distributors? What are the situations that generate more frequently such issues or conflicts based on I mean, your viewpoint? And do you have any suggestion on how to address those in a contract or during the life of a contract?
Sure. Well, I would say that in practice, what we have seen plenty of times, and it may also make sense to emphasize this during the last 3 years where we had a crisis worldwide, but default on payment, that's something that happens. I mean, because of different situations, not only because of force majeure, but the parties just face some complexities in their financials, and eventually they are prevented to meet their payment obligations. So that's something that happens, unfortunately, one day after the other, and not only with with small distributors. I mean, with big ones and with large companies. I mean, it's something that I believe can touch and can reach any type of company. On the other hand, problems that we do see often as well is failures in the timing for delivery of those products because of the transportation and the manufacturing facilities in China delay the production, and the shipment through Europe just stick down a few more weeks and so on. And by the end, the final client, taking the example of Mexico, did not receive the products on time. So that is also something that happens on a regular basis. To prevent that, I would say, well, it becomes to be relevant, of course, to have a clear terms and conditions in your contract where you have established, besides terms of payment and delivery conditions, well, eventually some guarantees, letters of credit, or something along those lines, in order to try to foresee those situations that may happen. I mean, penalties that eventually may help you at some point in time to ease, let's say, the process of enforcing your rights with your distributor, or even demanding that the manufacturing is able to deliver your products. Other conflicts that comes to my mind are failure to reach targets in sales. Normally, these type of agreements, because of the benchmark and market conditions, and it is tied to, let's say, the preferential rights that a distributor may have, but those are linked to certain expectation of the market. I mean, Mexico, which is with a big population, which has a potential market. I mean, those clauses are often exist. So problems also arises when, despite the objective circumstances, in order for the distributor to reach those sales targets are not met. And to that end, therefore, some exit clauses should exist. Actually, one thing, if I may, Roberto, to make just to draw an example, and it deals with the early termination clause. As I was mentioning, sometimes these agreements eventually start with some purchase orders, or even with an email, and somebody sends products from whatever elsewhere in the world, and they arrive to Mexico, and a few years later they say that they are not willing to continue. To that end, it may be an issue to exit those contracts. Again, since there is no law specifically providing for those provisions, it is essentially that by the time that you had the opportunity to enter agreement, you agree on an early termination clause. And to that end, that you provide what it may be reasonable in the conditions, 1 month, 3 months, eventually 1 year, because that varies from case by case. It depends on the investments that the distributor might have been done, whether it has been working for 2 years or for 20 years. But that is really important because at the end, although we have some criteria where eventually we may apply some rules for the termination of the lease agreements, which is 30 days, of course, that cannot be followed in every case, because as I was mentioning, if you happen to have a distributor with a relationship of 30 years and there's millions dollars of products in stock and with a sales force of, I don't know, a few dozens or hundreds of people, it wouldn't make sense that in 30 days term you can terminate a relationship. I mean, it would not be enough to mitigate any other consequences. So that early termination clause, I believe it is relevant because I mean, actually, in other countries in Latin America, there are a bunch of laws which actually protect the distributor, and essentially, in those cases, you are automatically bound to indemnify him, well, he or she or the company. So the point is that as long as you are able to foresee a reasonable period of time to terminate that contract, I believe it's a very good advice, because we have seen a lot of conflicts and disputes, some of them in courts or in arbitral tribunals, essentially deriving for having failed to foresee a period of time to early terminate that contract. Because by the time that you terminate it, if there has been not reasonable time to conclude that contractual relationship, of course, one of the parties may be claiming either damages or lost profits to the other party. So I believe that's relevant. And well, the not fun part of this is that when you start a relationship with a verbal commitment, or again with a purchase order, not necessarily those terms and conditions govern those details. So that is why it becomes to be relevant to agree in some, let's say, essential terms of those that distribution in the given country, and foresee this type of clauses.
Yeah, it's also my experience that in most cases, litigation or conflicts arise exactly at the moment of sending out a termination notice. So to cover exactly with a reasonable period of time that how to exit the contract is fundamental, as well as I would add, from my experience, to explicitly agree upon what are the rights and the obligations of the parties regarding the stock of products. So if at the moment of contract termination there is still a relevant stock of products, whether I, as the foreign manufacturer, would have the right, not the obligation, to purchase back and call back that stock, so that I don't want you to remain in possession of products which you would sell once the distribution agreement is terminated, which might be problematic.
Absolutely. And actually, one practical takeaway, if I may, Roberto, it's
Sure.
even having those provisions and having sent your termination notice in time, from a practical point of view, and we have lived this, I mean, many times, dozens of times, is that besides that, it is always advisable that by the time the decision to terminate a contractual relationship with your distributor, for example, it is strongly advisable that you approach him and try to agree on, let's say, a transition period, and to then negotiate I would say, a straightforward settlement agreement where you would say, okay, during these following 6 months or 12 months, you continue to sell your remaining stock, and I continue to do this and that, and try to I mean, if you have the ability to negotiate that, I believe you are in the safe side, because sometimes, even though having the entitlement to early terminate this contract, having this provision, a dispute may arise. And by the time that you are able to agree on this transition period, and provided that you have the consent of the other party, I believe is business-wise is I would say it's the more clever approach to end with this termination. Of course, that's not always not possible in all cases, but I strongly encourage the business people to strive in achieving that, because that's the best scenario to be in the safe side and prevent any dispute.
Surely. To wrap up this conversation, Joaquin, would you like to suggest the what's the most suitable dispute resolution clause that you should have in distribution agreement on the Mexican market? What is your take based on your experience? What's the most effective way to resolve disputes in between the parties?
Yeah, well, I would say, well, of course, I mean, we have competent courts that can have competence to resolve these matters. When you are dealing with I mean, a foreign factorer, something that you may want to explore is arbitration clauses. Arbitration clauses. I mean, and to that sense, I would say, I mean, there are reliable Mexican arbitration institutions. Of course, you need to see the size of the business. I mean, for a regular distribution relationship, you don't want to involve the ICC because it's just way too expensive. But I mean, there are reliable Mexican institutions like the Mexican Centro de Arbitraje de México, Mexican Arbitration Center. For example, I can give you the website to access those roles. They have their template model, and I believe that that works. And I would say, as in many other countries, some advantages very really for arbitration is the expertise of the arbiter or the tribunal, if there are three, and efficiency in the process. So I would say that in those cases, that may certainly be an option. And again, depending on the circumstances, eventually courts might also work. I mean, you need to have an overview. If there are those couple of local parties, well, eventually the courts may work also fine. And I would say that at the end, if your distributor is located in Mexico, you may want to have as governing law, Mexican law, in order to easily enforce that in Mexico. While you can also are free to choose for Swiss law, which may be okay, but in practice it would be kind of more complicated if you have a Mexican judge trying to apply Swiss law, although it is that may be allowed in our legal system.
You didn't mention, I'm curious, mediation. Is it popular or not? What's the trend in Mexico? Because we tend to see it more and more often in continental Europe, in the US as
It
well.
is, of course, it exists. It exists. I mean, at some point there are procedures. I mean, sometimes, I mean, you can commit in an agreement and to that end set for a procedure. There, in our experience, I mean, yes, of course, it may be another ADR, another dispute resolution mechanism. Sometimes the parties believe that at the end, if they are not able to make that binding, that they are losing that period of time, and they would like to elect directly going to courts or arbitration. Correct. But well, I would say that actually nowadays, I mean, there's a new regulation which actually license some mediators where eventually they can participate in this process, and to that end help in, let's say, as I was referring, reaching a settlement agreement. By the time that you conduct this negotiation process through a licensed mediator, that can give you the status of having a dispute as res judicata. So in that sense, it may also be an alternative to explore.
Well, we
So
can
yes,
provide the links to the arbitration chambers and
absolutely,
mediation institutes that you would recommend. I think this is an excellent spot where we can wrap up this chat.
absolutely,
I will also provide the link to the guides and the materials which are available on our website. And thanks a lot, Joaquin, for this chat. And until next time.
absolutely. Thank you very much, Roberto, for the opportunity, and I hope this has been helpful in a nutshell. And sure, I will be sending those links for you.
Thank you. Bye bye.
Have a great